This is Tyler O'Neill with the Daily Signal. I'm honored to be joined by Hans von Spakovsky, who's a senior legal fellow here at the Heritage Foundation. Hans, it's great to have you.
Right. I think it means also I'm kind of a general legal troublemaker.
Well, only good trouble, right?
Right.
Well, I think the president got into a little bit of legal trouble, and then the Ninth Circuit got him out of it. Would you just walk us through this astonishing last 24 hours we had?
Sure. And that Court of Appeals acted within hours, within hours of a lower court decision. Look, what the president did is something he is statutorily authorized to do, much less looking at his constitutional authority as commander-in-chief. There's a statute. It's 10 U.S.C. 12406, and it provides for the federalization of the National Guard. National Guards are usually under the province of the governors of each of their states, but under certain circumstances, they can be federalized and basically they become federal troops, just like the 101st Airborne or the U.S. Marines. And there's 3 occasions where that can be done. One is if the U.S. is being invaded. Second, if there is a rebellion going on within the United States. And the third is if the president is unable with the regular forces, so they're talking about regular law enforcement, to enforce the laws of the United States. He used that third provision to federalize the National Guard and send troops to L.A. to try to protect federal law enforcement, particularly ICE agents, and to stop the property damage of federal buildings. I mean, we've all seen the videos of what was happening. We saw, wasn't it the police chief, Tyler, who said it's out of control?
It was.
It was. And so he was acting well within the statute. But, of course, Governor Newsom, as you know, sued.
Yeah.
And said, we don't need federal troops. As we're watching these videos of violent attacks, arson, looting going on in L.A., and Newsom is saying, no, we don't need federal troops. So they filed suit. And they almost immediately got an order from Charles Breyer.
That name sounds familiar.
Well, it should, because he's the brother of former ultra-liberal Supreme Court Justice Stephen Breyer. And
that's it.
You know what would have shocked me is if he had ruled for Donald Trump, because knowing Charles Breyer and his previous history, he's got a lot of it. There's no way he would have ruled for Donald Trump, no matter what the law says, no matter the Constitution. He issued an injunction saying that the president had illegally taken control of the National Guard beyond his statutory authority, and that he had violated this. This is actually funny to me. He had violated the 10th Amendment. Now, the 10th Amendment, as you know, is the amendment that reserves power
rights
to the states
and the people.
When was the last time a liberal judge paid any attention to the 10th Amendment? I mean, liberal judges believe the federal government has the power to do anything, right?
Except enforce immigration law.
Yeah, except enforce immigration law. And the Ninth Circuit moved almost immediately to stay the decision while they take a look at the case. Look, the Ninth Circuit, as you know, is a very liberal court. They might, once they've looked at it substantively, rule against the president. But I have no doubt that in that case, they will file an emergency appeal with the U.S. Supreme Court, and Trump will win. This is really not a gray issue. The statute's very clear. I mean, the only thing they're trying to hang their hat on is that Newsom is saying, "Oh, we can't do this without my permission."
Right.
And they're relying on this language. Look, it's a very short statute. People can look at it. It's literally just one paragraph. It's not very long. It says when the president issues an order like this federalizing the National Guard, he's supposed to issue his orders through the governor. So in other words, what does that mean? Well, he's supposed to notify the governor, essentially, that he's doing this. That does not say that he has to get the permission of the governor. And if you think about this statute and the second provision, remember the second provision was if there's a rebellion or danger of rebellion against the authority of the government, It wouldn't make any sense to say the president has to get the permission of the governor. What if it's the governor
Who's rebelling?
Right,
Yeah.
who's rebelling the way the governor of Arkansas was in 1957. Folks may forget. Remember, the Supreme Court issued the Brown versus Board of Education decision saying schools had to be desegregated. And what happened in Little Rock, Arkansas? The governor, state officials, local officials, and mobs were resisting the desegregation of one of the high schools there. And what did Dwight D. Eisenhower do? Sent in federal troops to protect those black students and to make sure they were not assaulted and have things happen, have bricks thrown at them, as has been happening in L.A. I guess it's a good thing that Charles Breyer wasn't a judge in Arkansas at that time, right?
Yeah, well, I wonder what Gavin Newsom would say about that comparison.
Well, no, I think it is a historical parallel because the governor of the state of Arkansas was saying 10th Amendment applies. You cannot apply federal civil rights laws to us here in this state. Your federal officials don't have a right to come down here and do that. And what is Governor Newsom saying? He's saying federal immigration laws, well, they don't apply in California. And no, you can't come here and enforce those laws in California. It's the same thing.
So zooming out, we've seen a lot of these injunctions. This
Right.
story plays out time and time again. Trump takes an action to enforce immigration law or change the former Biden policy. And then you have a lower court judge slap an injunction on there, usually a universal injunction, nationwide injunction. And then a higher court strikes it down. Right now, this is also a live case before the Supreme Court now because of the order on birthright citizenship.
Right.
How do you see this likely playing out? You know, you mentioned in this case, even if the Ninth Circuit rules against Trump, the Supreme Court's likely to uphold him. But, you know, after we've seen so many of these,
Right.
and the Supreme Court, we all know Justice John Roberts wants to maintain the appearance of neutrality of the court. If he's having to constantly stand up for Trump, he might not like doing that.
Well, he might not, but on the other hand, in the last month, and we're getting towards the end of the Supreme Court's regular term, end of June, they have been, with more frequency and faster issuing emergency stays of all these lower court decisions in case after case. I mean, we're talking about immigration here, and just within the last 2 weeks, the president ended the mass parole that the Biden administration, frankly, had unlawfully issued to 500,000 illegal aliens from places like Cuba and Nicaragua.
Venezuela,
The President Trump ended that. You had a lower court say, oh, you can't do that. And the Supreme Court stepped in and issued an emergency stay of that lower court decision, which means that they can end mass parole and they can start deporting those individuals.
So, yeah, you think this is likely to continue?
This is likely to continue, and I think even when the Supreme Court goes out, end of June, they issue their final decisions, they take the summer off, they won't be back till October. But you can continue to file with them. And given the pace of litigation, there's been I think by now we're up to probably 220 lawsuits filed against the Trump administration. Even this summer when they're supposedly on vacation, they're going to continue to receive emergency requests for stays because of this kind of, frankly, it's rogue judges. Mm-hmm. And it's lawfare, judicial lawfare of the worst kind.
How do you restrain the judges in the lawfare?
Well, there's two things that need to happen. One, you mentioned the birthright citizenship case. That case is up before the Supreme Court on an emergency stay. They're not going to decide the substantive merits of the issue. In other words, is Trump correct or not on birthright citizenship? The issue is the nationwide stays. There were 3 of them issued in that case by 3 different judges, okay? So the whole oral argument for the court was, well, When are nationwide injunctions appropriate? When do judges have the authority to actually issue those? So I think by the end of June, we're going to get a decision in which I hope the Supreme Court reemphasizes and lays out very restrictive rules that they say courts have to follow, not just in this case, but in any cases where they want to issue nationwide injunctions. The other thing that's happened is, as we all know, they've been forum shopping. Yeah. If you look at these nationwide injunctions, they're not filing cases in places like Texas or Georgia.
Why would that be?
Yeah, they're filing them in just a couple of places: Maryland, Massachusetts, Washington State, California. Why? Well, because they're looking for very liberal ideologues who happen to masquerade as federal judges, because they know they'll get a good ruling, at least from their standpoint, from them, no matter what the law is, no matter what the claim is. The House has passed a bill that would say that if you are suing over, for example, an executive order, it has to be assigned to a 3-judge panel. So that would hopefully cut down on a lot of the shopping for just one particular federal judge. And you would get a direct appeal as of right to the U.S. Supreme Court. So that would cut down the delays in going through the appeals courts, and the Supreme Court would have to take the case. Pass the House. It's now in the Senate. I think Senator Thune, it would be a good idea for him to try to see if he can get that through.
But that would need a 60 vote.
Yeah, they'd have to overcome a filibuster, so that may not be possible, but I think they've got to try to work on it.
Yeah, I think it would be a good thing to push for.
Yeah.
Well, is there any, I think of Rule 65C. I don't want to go too into the weeds.
Oh, no, but that's an important if there's a rule in the federal courts that says that if you're going to appeal a decision, or if you're in a situation where you've received an injunction, you're supposed to put up a bond that covers the cost if it turns out you were wrong. In other words, if you've gone to court and within a couple of days the judge has issued an injunction telling the other side, this place, the government, you can't take the actions you're taking. You're supposed to have to put up an a bond before you can get that injunction, because if a later court rules you're wrong, it may have cost the other side a lot of money. Judges haven't been requiring that. Isn't that a shock? These liberal judges have not been requiring folks to put up bonds, or they just say, put up $100. Well, you're not supposed to do that either.
Well, I heard there's an exception for public interest litigation. FIRE, the Foundation for Individual Rights in Education, and Expression actually now, has said that, applying Rule 65C would have a chilling effect on laws that block abuses from the executive. How do you respond to that idea?
I understand that as a concern, but at the moment, we have the abuse all happening on the plaintiff, the challenger side, and we've got to do something to fix that.
In cases against the government usually isn't forced to put up a security in situations like that, correct?
No, they're not. But the situation is such that think about the 500,000 illegal aliens who were on, basically had been paroled.
Yeah.
If we were continued to force to keep them here because of the lower court injunction, the costs that they impose on the American taxpayer, housing, medical costs, judicial costs through the criminal justice system are enormous.
Yeah.
And what, we the taxpayers are supposed to pay for all that if it turns out later that that initial judge improperly put out an injunction? That's the kind of thing people have to think about in these cases.
Well, thank you so much, Hans, for joining us. Is there anything
Sure.
else you want to add about the...
No, other than the legal fight we're seeing, I've never seen anything like this, and I've been a lawyer for a long time. So it's very important, and a lot of the future of the country depends on how this comes out.
Well, thanks again. Where can people follow you?
They can follow me at heritage.org or at the place where you write a lot, the Daily Signal, because I publish there all the time.
Yeah, you always have excellent columns.
Thanks.
Right is still right, even if you stand by yourself.
Mr. Chief Justice, may it please the court.
This is Hans von Spakovsky, host of the Case in Point podcast, which looks at the hottest cases affecting politics, culture, and everyone's daily lives. But we talk about them without confusing legal jargon. And we have interesting guests, like former House Speaker Newt Gingrich. And we end with reviews of classic Hollywood movies relevant to the topic. Case in Point, the podcast available everywhere you won't want to miss.